What happens if you suddenly can't afford your alimony payment anymore? Maybe you lost your job, your income was cut. You're facing a serious medical issue, or you're approaching retirement. Can you just stop paying? No, and doing that could make your situation much worse. In Florida, your alimony order stays in effect until a judge changes it. If you stop paying on your own, you could face contempt, wage garnishment, liens, growing arrears, and potentially even jail. But if your financial circumstances have genuinely changed, you may have a path to reduce or terminate your alimony. And one thing is critical: the sooner you act, the better. Don't just stop paying. If your court order says you owe $3,000 a month, you generally still owe that $3,000, even if you can no longer afford it. Your financial situation changing does not automatically change your court order. If you simply stop paying, the unpaid amounts can become arrears, and those arrears can continue to grow. Depending on the circumstances, enforcement can include wage garnishment, interception of tax refunds, property liens, license suspension, and contempt proceedings. So what should you do instead? Ask the court to modify or terminate the alimony order. How can you reduce alimony? You generally need to show that something significant has changed since the original order. The change typically needs to be substantial, material, involuntary, and not anticipated when the order was entered. Examples can include an involuntary job loss, a significant involuntary reduction in income, a serious illness or disability affecting your ability to work, retirement under circumstances recognized by Florida law, or a significant improvement in your former spouse's financial circumstances. But not every financial problem qualifies. For example, voluntarily quitting a job or intentionally earning less can hurt your case. Taking on new voluntary expenses, like a more expensive home or car, generally doesn't automatically justify reducing alimony either. The court wants to know why your ability to pay changed, and that's why documentation matters. Pay stubs, tax returns, termination letters, medical records, and other financial documents can help show the court what actually happened. Here's why filing quickly matters. This may be the most important part of the video. Don't wait months hoping your situation will fix itself. A modification can generally be applied retroactively only to the date you file. So let's say your alimony payment is $3,000 a month and you lose your job in January. If you wait until June to file, you could have 5 additional months of the original obligation accumulating before you even ask the court to modify it. That's potentially $15,000 in additional payments. The exact outcome depends on your circumstances and the court, but the point is simple. When your financial situation changes substantially, don't wait to address it. What about retirement? Retirement can also be an important issue in an alimony modification. Florida law allows courts to consider retirement when determining whether alimony should be reduced or terminated. The court can look at factors such as your age, health, occupation, customary retirement age, motivation for retiring, and your former spouse's needs and resources. And here's something many people don't realize. You may be able to file up to 6 months before your actual retirement date. That means you don't necessarily have to wait until the day after you retire to start addressing the issue. If retirement is approaching, planning ahead can be extremely important. What if you're already behind? Maybe you're already several months behind. That doesn't necessarily mean you have no options. But filing a modification does not automatically erase the arrears that accumulated before you filed. The court may still be able to reduce your future payments, but the past due amounts can remain. That's why acting quickly is so important. And if you are already behind, make a good faith effort to pay what you reasonably can while documenting your financial situation. Showing the court that you tried to comply can be very different from simply refusing to pay. Can you go to jail? This is another question we hear. Can I actually go to jail for unpaid alimony? Potentially, yes. But jail is generally a last resort. If your former spouse brings a contempt action, the court can examine whether you had the ability to pay and whether you willfully refused to comply. That's why evidence matters. If you genuinely cannot pay because of a major involuntary change in your circumstances, you want to be able to prove that. And if you're already facing a contempt proceeding, you should address it immediately. What should you do now? If you can no longer afford your alimony, remember these 3 things. 1. Don't simply stop paying. Your current order remains in effect until a judge changes it. 2. Document the change. Keep your pay stubs, tax returns, termination documents, medical records, and other evidence showing what happened. 3. File as soon as possible. The date you file can matter significantly when determining how far back a modification can apply. If your alimony obligation no longer matches your financial circumstances, don't wait until the arrears become overwhelming. The family law attorneys at Nest Law help Florida clients with post-judgment alimony modifications and terminations. If you've lost your job, experienced a major income reduction, are approaching retirement, or are already struggling with arrears, visit Nest Law to learn more or contact the firm to discuss your situation. Don't stop paying and hope the problem goes away. Take action before it gets bigger.